In a democracy, judiciary plays a very, very important role in interpreting the laws, acts and rules. As we all know, we have three important wings. One is legislature, the second is judiciary, and third one is executive. The acts which are enacted by the legislature should be implemented by the executive. The legislature which is enacting the laws or acts should be thoroughly implemented without any misrepresentation. What is happening in this process? When the governments are not keen, when the governments are biased, the representation of the act or implementation of the act is not done in a proper way. When that is not being done, again, the court is the ultimate recluse. The court is the ultimate source to go and fight for the rights or to make the government or the legislature to look into that misrepresentation or violation or non-implementation. So in this process, we have very interesting background. Today, in Telangana movement, we are trying to understand the role of the courts, the role of the court judgments in Telangana movement, in the issue of interpretation, in the aspect of MULKI rules and how it is being affected the movement inter alia, like many court judgments which came at an appropriate time or inappropriate time, helped or diffused the movement. And many a times court judgments were very favorable of the people of Telangana, and some court judgments really disappointed them. Why it happens? To understand, because when we are talking about the same court of law, whether it is a local court, whether it is a high court or a supreme court, when we discuss about these courts and the verdicts, why it differs from bench to bench, judge to judge? Because the aspect of interpretation, the problem of interpretation or argument. See, when an issue is raised before the court, what will happen? The arguments will be held. The advocates, the appellants or the defendants, what are the main aspects they are trying to touch or appeal before the court is very, very crucial. If you are not defending or fighting the case with a particular orientation, means taking the important aspect into the center of the argument, you may lose the case. Like that, in many of the issues we have seen, the court cases lifted the movement or encouraged the movement, means it will not directly encourage. Once a court case is coming in favor of the movement, then definitely people are fighting with the state or the government to get it implemented. Like that, we have many cases. In Telangana movement, if we see, we have nearly 7 important judgments. These 7 important judgments were coming at a juncture when the Telangana movement is starting. The period which we are covering is from 1969 to 1972, when we see 7 court judgments and the nitty-gritty of these judgments, its impact on the movement. If we go through the list of the judgments, the first one is Justice Kuppuswamy verdict on MULKI rules in APSEB, January 1969. Then second one is Justice Chinnapareddy verdict on 3rd February 1969. These first 2 verdicts were not in favor of Telangana employees. And third judgment, High Court Division Bench quashes Justice Chinnapareddy's verdict. Then fourth one, MULKI rules are unconstitutional, says the Supreme Court full bench on 28 March 1969. Then again, MULKI rules are constitutional, says High Court full bench on 9 December 1970. Then MULKI rules are void, means not constitutional, says HC full bench on one Venkat Reddy appeal. This is happening on 14 February 1972. Then comes the last judgment which has put the full stop for all these cases of 1969 phase, that is MULKI rules are constitutional, says the Supreme Court full bench on 3rd October 1972. So let's look at into these things in detail, and before that we have to understand the background for the judgments on Mulki rules. If we briefly recap the whole issue of Mulki issue, the first phase or the first time we are talking about the Mulki issue in 1880s under Mir Mahbub Ali Khan. First time the Mulki issue has cropped up in terms of the locals and non-locals. The locals are Dakhanis or Hyderabadis, and non-locals are the people who are coming from North India or some other part of the country and occupying the important post. First time the rumblings, first time the resentment or dissent was happening during 1880s under Mir Mahbub Ali Khan. But later many things are coming. We are not going into those things as we have already covered. So come 1900s. In 1900s, in 1919 to be more specific, Mir Usman Ali Khan's Farman is very important. Mir Usman Ali Khan's Farman, the last Nizam, the 7th Nizam, Mir Usman Ali Khan's Farman of 1919 clearly mentioned the eligibility for a Mulki, that 15 years of residence, and the other aspects like marriage status, how if you are marrying a Mulki, becoming a Mulki, or residence here for 15 years, so that, and giving an undertaking that you will not leave after the retirement also. Like that the Mulki rules were made very strict to favor the locals. This is 1919 Farman of Mir Usman Ali Khan. So in independent India after 1947, as we have seen after 1947, in 1948 only, Hyderabad state became part of the Indian Union for all practical purposes, for administrative purposes. In 1949, the Civil Services Regulation was being enacted. This Civil Services Regulation was brought under the military government under J.N. Chowdhury, but it is not much difference. But he was promulgating or he was issuing the same 1990 Mulki Farman of Mir Usman Ali Khan, and this is the first one in the post-independence India or post-Hyderabad state of Nizam. The other aspect is Article 35B of Indian Constitution. Remember this, Article 35B of Indian Constitution gave constitutional validity for the Mulki rules from 26 January 1950. Hyderabad state was included in Article 35B. Why? Because it has a specific historical background when it is being part of India, when it is being taken into India or merged into India. So, in this background, since Indian Union is having different states with different backgrounds, different periods, different historical accounts and different political setup, but Hyderabad is becoming part of it. And Hyderabad is completely different with already existing Mulki rules of 1919. So, safeguarding this Mulki rights of the Mulkis, rights of the locals, this Article 35B is very, very important. So, Article 35B gave the constitutional validity for the Mulki rules through our constitution. Otherwise, what will happen once a state is merging with the other country? You may not get the same aspect as you will have before because rules are completely changed. It's a different story, a different country altogether. So, Constitution has made a provision for this. And next, Hyderabad General Recruitment Rules of 1955. What is this Hyderabad General Recruitment Rules of 1955? It was issued with the signature of Raj Pramukh. Who was the Raj Pramukh? Mir Usman Ali Khan. When the constitution came into force, as we all know, Mir Usman Ali Khan became the Raj Pramukh, who was signing as the Raj Pramukh, and the chief minister was Burgula Ramakrishna Rao. And this Hyderabad General Recruitment Rules of 1955 very clearly says, for the appointment of state or subordinate services, these are the rules. 1. No individual who is not an Indian citizen can be appointed. This is coming in a different background because it's a new country and many people from different countries were there and going or coming, and this is the first stage. So, Indian nationality is a must. Even today, if all the rules, if you see for appointment, nationality is a crucial issue. Without, if you are not an Indian national, it's not so easy to get appointed in this country. So the first rule is about the citizenship of the country. Second one is must have the 15 years of local residence certified by the designated authority. An authority who is authorized to certify that this person is living for the past 15 years in this state. So this is the second rule. Those 15 years again you can take back to the MULKI rules of Hyderabad state. 15 years of rule, the rule of 15 years is going back to MULKI issue, the of Hyderabad state. So next one is AP Public Employment Recruitment as to Residence Act of 1957. Why? What is the need of this act? In 1956, a new state has emerged, that is the state of Andhra Pradesh. The state of Andhra Pradesh, which came into existence as a result of merger of Telangana area of Hyderabad state with the Andhra state. So now again you have to form the rules or act. That act is known as AP Public Employment Act. So in AP Public Employment Act, which was enacted in 1957, rules were made in 1969. Rules formulated and implemented from 21st March 1959 means actually act was made in 57, but rules are being formed in 59. You can see the difference, the delay in implementing the things. So the eligibility for the appointment and subordinate services and local bodies, except cantonments, because cantonment is also a local body. All the rules, when we speak of the MULKI rules, you see, except cantonment. Why cantonment is excluded? Cantonment is coming under the purview of central government. Though cantonment local body is there, it is not the state government which has to rule or oversee the administration of cantonments. So cantonment is military. So 15 years of residence, and second thing is, this is crucial. When they talked about this 15 years of residence, the second aspect in 1957, this is very, very important, remember. Violation of this has made the life hell for the Telangana employees or Telangana aspirants. Every second post out of 3 vacancies in HOD offices, head of the department offices in Hyderabad and Secunderabad and secretariat is reserved for MULKIs. Every second post, remember, if there are 3 posts, 1, 2, 3, and the second post is reserved for the MULKI, they are not saying that every 1 post out of 3. They are saying every second post out of 3. Why this is important? This is a small, measure, but it's an important measure. See, if you say every 1 in 3, then you may not get 3 vacancies at a time. You may create 2 vacancies, then what will happen to the vacancy of the second one? So whenever you have to create, if you are stopping by creating 3rd vacancy, then automatically these 2 vacancies are also gone. So automatically what they are doing is every second vacancy, they are giving the second vacancy to a Telangana person, a MULKI, to be filled with. So this every second vacancy, how the violation happened in the next phase? Very interesting thing. When they are notifying for 3 vacancies, this second vacancy also they are notifying. But when they choose the employees or elect the employees or select the employees through interviews or whatever mode, they are saying that this second employee or second post, for the second post, the MULKIs which is reserved for this, the people who are coming for the second post are not eligible or fit for the post. So automatically this is not being filled. This is notified but not filled. So 1 and 3 are filled. This is very interesting phenomena, or very interesting story, very interesting violation to deceive the people of Telangana when it is coming into implementation. So this is AP Public Employment Recruitment as to Residence Act of 1957. Then comes, this is applicable for 5 years only. Till 21st March 1964, the rules which were formed in 1959 will be applicable for 5 years. Act 57 rules 59. Then add 5 years, it comes to 1964. This is applicable for 5 years till 21st March 1964. And because this is not implemented, this non-implementation of the MULKI rules was protested by Telangana Regional Committee or employee organizations, as it should have been done in all the past 5 years. So automatically what is happening? The government was extending this for further 5 years, and the next deadline is till 21st March 1969. So 59 to 69, 10 years of period, this AP Public Employment Act is guaranteeing every second post out of 3 posts for the MULKIs and 15 years of residence. This is the crucial issue or important aspects of this act. So what has happened in this 10 years? Though they formulated rules, it was not implemented. As a result, first extension. So after extending also in 1968, we could see a huge movement for the safeguards. That is why the movement which started in 1968 by Telangana employees is known as Safeguards Movement. Safeguards Movement started by TNGOs under the leadership of Amos, K.R. Amos. Violations occurred in spite of this act, and as a result, this Safeguards Movement by TNGOs was happening in 1968. Remember, you may get a question in objective type. What was the major issue for the Safeguards Movement? That is violation of AP Public Employment Act. Then comes very interesting aspects. In 1969, what has happened? The movement broke from Khammam, Palvancha, and spread to the entire country. Country in the sense I am talking in terms of Telangana. Country not in terms of nation or India, the land, Telangana land. In January, there was a verdict, that is Justice Kuppuswamy verdict regarding the employees of APSEB. APSEB, some of the employees were retrenched from AP State Electricity Board, and they approached the court. Why they were retrenched? This is the first story, first important aspect. In 1968, when K.R. Amos and all these people has brought the agitation to the doorsteps of the government, the whole movement was serious about the employment. The whole movement was about the employment safeguards for the employment in the state government jobs. So what has happened? The government came out with a GO saying that all the non-MULKIs should be sent to their native states. That is, native state in the sense it is Andhra Pradesh. Andhra state before 1956. So the employees from Andhra should be sent back to Andhra, and if at all there are no posts, create supernumerary posts and people should be taken there, and the employment or the vacancies which are arising out of sending the non-locals to their native areas should be filled with the Telanganites. That is how the rules were formed or the GO was issued. Once the GO was issued, in some of the departments, like the GO was issued on 30th March 1968, and some of the MULKIs, some of the non-MULKIs in Panchayat Raj, Electricity Board, Education were removed or transferred or removed from the posts in Telangana, and they have to be rehabilitated or sent to Andhra once they are removing here. Even that rule says it is unconstitutional. We did not implement the rule, so we have to send. This is the matter which was written in the rule by the government. This is not happening out of greatness, out of magnanimity. It is happening because of the pressure applied by the TNGOs in the government, with the government. So, when these people were retrenched, what is happening? These people approached the court, and Justice Kuppuswamy, Alladi Kuppuswamy, has given a verdict saying that since AP State Electricity Board is an autonomous body, the rules of Public Employment Act is not applicable. If we go through the original act, What is written in the Act? Subordinate services of state or state government, and APSEB, it's a board and it's autonomous. So what you call interpreting the whole thing, like APSEB is an autonomous body, so the Public Employment Act is not applicable for them. So you have to take back the APSEB employees who were retrenched. This was the verdict of Justice Kuppuswamy. This is not in favor of Telangana employees. And this verdict is coming on 3rd January itself, before the launch of the 1969 movement in the first week, or from 9th onwards or 8th onwards, you have the intense movement beginning, the rumblings happening in Khammam and all those areas. So this judgment is the first one. And second one is Justice O. Chinnapareddy's verdict. O. Chinnapareddy gave a verdict on 3rd February 1969. And this verdict is coming in the backdrop of GO number 36. GO number 36 came in the month of January. In the month of January, when the agitation started in Khammam, it spread to all the Telangana areas, towns. Hurriedly, the state government under Kasu Brahmanand Reddy called for a meeting of all parties, and the GO number 36 is a result of this all-party meeting. That GO number 36 is talking about the MULKI issue. The first statement, or the GO number 36 and the all-party meeting gave a statement saying that, yes, we do accept that the safeguards or the provisions for Telangana were not implemented. They are accepting it. As they have accepted, again they are issued a GO number 36 favoring Telangana employees. When this GO number 36 was given, again people went to the court. This GO number 36 was contested in the High Court, and Justice O. Chinnapareddy was saying that MULKI rules for Telangana region are void. It's unconstitutional. The Section 3 of the Public Employment Act, residence in brackets, rules framed along with this act. Then amendment of 1964. In 1964, one amendment or one extension was given because of non-implementation. When the protest is from TRC, again this act was extended for 5 more years so that it will be beneficial for Telangana employees. So Chinnapareddy verdict says this is also unconstitutional to extend the residence clause. And finally, the GO number 36, which is favoring Telangana MULKI issue, is also void. So Justice Chinnapareddy verdict is a verdict which is against the interests of the Telangana people. So what has happened? The government has appealed before the High Court division bench on this verdict. What will happen whenever you have a verdict with a single judge? You may appeal further. You may appeal the High Court or the higher process, so that if you are not satisfied with the verdict. So similarly, what has happened? The government has appealed before the High Court, and the division bench is going to discuss about this verdict. So till now we can see the first part of the movement. When the movement is beginning, just before the movement itself, you have got a verdict, that is Justice Alladi Kuppuswamy verdict, quashing the rights of the MULKIs, quashing the MULKI rules. Not in all the areas. He says, when you are approaching, that's what in the beginning I said, when you go to the court, when you approach the court, you will be talking about the court with reference to one particular aspect. It was the APSEB employees, retrenched APSEB employees. They took the argument that APSEB is an autonomous body. So automatically the verdict will be focusing on the nature of the APSEB, and finally the verdict comes as if APSEB is an autonomous body. As a result, what we have seen is APSEB rules, APSEB is out of MULKI rules. Then comes Justice Chinnapareddy's verdict. It is again based on the GO number 36, which is a result of the agitation. The agitation of at least 9 to 19th, almost for 10 days, the intense agitation and the what you call pressure generated in the Telangana society on the government is forcing the government to bring the GO number 36, and that GO number 36 is challenged in the court. And now you see GO number 36 is becoming the discussing point. And not just GO number 36, it is not the what you call the aspect how you are issuing a GO, but they are discussing, means Justice Chinnappa is discussing the section 3 of the Public Employment Act, that is residence aspect, and the rules, and finally the extension in 1964, and even the GO itself. So all things are becoming unconstitutional. This is Justice Chinnappa verdict. So to sum up the first part of the court judgments, what we want to say is, this first part is very, very clear, and it is about the beginnings of the interpretation of court judgments in MULKI issue. And Telangana is always a MULKI. In Telangana, the agitation or the state demand is based, or it is always revolving around the MULKI issue. As we have seen, if we say the first verdict is Kuppuswamy's verdict, Justice Kuppuswamy's verdict, the last verdict is, if you see, that is 14F, which has completely changed the course of agitation, the course of the movement, which entered into the phase. And finally this 14F and local Hyderabad free zone, all these things are related to the court, related to the verdicts of the court. And these are the issues which stirred the issue of Telangana state, as we see. So in the next part of our court judgments, we will be looking in the other court judgments.